Hello, good morning to all who are starting their day, and good evening to all that are already wrapping it up. We have a truly global audience today with attendance from Asia, Europe, and the Americas. First of all, I hope you're all in good health and keeping yourselves and your family safe in the midst of this pandemic. I also take this opportunity to inform you that our offices in the BVI and NIBIS are under severe weather storm warning. So NIBIS public offices are closed for the day, and BVI public offices are closing from 1 p.m. today. Our offices are following the same schedules, and we will do our best to provide you with the best possible service given the situation, with our staff working remotely. Thanks for joining us for this webinar on economic substance in the BVI. This is a very important topic for everyone who has a BVI entity, especially now that the first financial period for entities incorporated prior to January 1st, 2019 just ended exactly 1 month ago. During this webinar, we hope to answer questions you may have regarding whether your BVI entity is in compliance with economic substance regulations or not. For example, is your entity conducting a relevant activity? Does your entity fall within the scope of economic substance requirements? When is your deadline to report? And as your agent, how can OMC help you comply with economic substance? Please feel free at any point during this presentation to ask questions by using the Q&A section in the bottom part of the screen. At the end of this presentation, you will receive a brief survey where you will be able to share your feedback with us. Your opinion is very, very valuable for us, and we are keen on learning what other topics would be of interest to you to learn from future webinars. So let's start with our presentation. Our speaker today, Manuela Fogarty, is our operations manager in OMC. Manuela is a trust estate practitioner and has over 25 years of experience in the corporate services industry with degrees in both law and business administration. I hope you enjoy this presentation and find it of great value. Thanks. Manuela, I give you the word.
Good morning. Good morning. Thank you, Isabel. Good morning and welcome to OMC. This year we're celebrating our 65th anniversary, and although the year has not been a very good one to everybody worldwide, we do not intend that to lessen the excitement we feel of achieving this milestone. So without further ado, let's start our presentation. Economic substance matter has been in our minds for over a year now. And this is our BVI economic substance, everything you need to know, in an attempt to make it accessible and easier for our clients to comprehend the conundrum ahead of us. In our agenda, we have the evolution of an international standard, so that we all know where this comes from, the economic substance legal framework in the BVI, the Economic Substance Act, a few pointers on it, the relevant activities themselves, what needs to be done to achieve or to meet the requirements of the legislation, the 3 options that clients have if their company is within the scope, the 5 economic substance requirements that need to be met if the company needs to materialize its operation within the BVI. Where are we at this point in time? The BOSS economic substance module, which has been online and working for more than a month now, and some final thoughts on the whole matter. So where does all the economic substance matter issue or movement, let's say, come from? In 2016, the European Union adopted criteria covering tax transparency. You might know that the OECD has been on the matter of fair tax transit, the fair tax, level tax terrain for all of the countries in the world. So the OECD moved this intention or this movement to the European Union, and they evaluated they had a screening process that went through in 2017, evaluating all of the jurisdictions and countries around the world. The BVI meets the European Union criteria on transparency, anti-BEPS. Remember that BEPS is for base erosion and profit shifting, and meets all of the general principles that they established. But the EU still required further assurance from the BVI on economic substance matters. The OECD has adopted economic substance requirements to be applied to jurisdictions that levy low or, like the BVI, zero corporate income tax. This means that economic substance rules will no longer be an European Union standard, but a global standard. The economic substance legal framework. Let's talk about the Economic Substance Act. The Economic Substance Companies and Limited Partnerships Act 2018 was passed on very late December 2018 to become effective on 1st January 2019. It defines the relevant activities, which are 9, and the core income generating activities. This SIGA means core income generating activities, which each relevant activity has a series of core income generating activities that belong to that relevant activity to know whether your company is or not within the relevant activity, and the specific requirements for each one of the relevant activities. Establishes the scope to which companies and limited partnerships that do not have a juridical personality. Introduces changes to the BOSS Act, which are not to the BOSS Act, but it concatenates the legislation for the economic substance with the BOSS Act. Then we had the Economic Substance Companies and Limited Partnership Act 2019, which was a very small amendment that they introduced that establishes that Section 16 will become effective on 30 June 2019, or as announced eventually through the Gazette. The most important thing that this very brief amendment did for economic substance legislation was changing the term shares for equity participations. You know, shares are for companies that are limited by shares, as example, corporations or international business companies or business companies, whereas equity participations include several other forms of shares, particularly quotas, that are usually the way that limited partnerships or limited liability companies have their quota participation. So this widens the scope of the term. And then there was a notice under the Economic Substance Companies and Limited Partnerships Act that established 1st October 2019 as the date that Section 16 of the Economic Substance Companies and Limited Partnership Act would become effective. And then we have the BOSS Act. The BOSS Act, the initial, let's say, came out on 2017 and introduced the beneficial owners secure search system, and the obligation of the companies to enter the data for the beneficial owners in the portal. And it defined the scope of the application. Then, just later on in 2017, there was the first amendment, which improved the definitions within the BOSS, and at the time, exempted struck-off companies from providing the information or entering the information in the portal. So only active companies had to post their information, the beneficial owner information in the BOSS. By late 2019, the BOSS issued its second amendment, which what did was to concatenate the BOSS Act with the Economic Substance Act, and it increased greatly the amount of information that needed to be reported to the portal to make it work as the portal to eventually report economic substance. And then we had a second amendment, shorter actually, that included the International Tax Authority of the BVI, as well as the Financial Intelligence Agency as competent authorities dealing with this matter. It also granted faculties to the International Tax Authority to access beneficial owners' information when necessary, as well as the FIA. Then, what is the Economic Substance International Tax Authority rules? This is the document that makes all of the other, that helps us understand better and know how the whole economic substance matter is going to actually work. So the authorities shared a draft economic substance code on 22nd April 2019 to all of the registered agents so that we could comment on the contents and the regulation. It acts as a regulation for the law, and it defines the scope of the Economic Substance Act in detail, and most importantly, it provides examples on how everything was going to work and what information would have to be uploaded to the system. It provided practical examples, and it was very, very useful for all of us to know how what was stated on the law was going to happen in practical terms at the end of this matter. Then they issued the rules, because the first draft was only for comments. The rules were actually issued or enacted on 9th October 2019 and provided even more examples. It was a more comprehensive document than the one that had been circulated on 22nd April, most probably because of the cooperation of the registered agents, as well as further development on the part of the authorities. And we already have version 2, which was issued on 10th February 2020. One of the important items is that this second version included tax transparent entities. And the tax transparent entities mean entities that in the country where they are operating or domiciled, etc., this is legislation that has to be provided in that place, not in the BVI. It has nothing to do with the legislation of the BVI. In some places, there is a possibility to register tax transparent entities, meaning that the income of the entity is not subject to corporate tax, but rather it flows to the shareholders, and then it's taxed on the shareholders. When their shareholders, the physical persons, make their annual return, they declare all of their income, their regular income from work or whichever other source they have, and then they list the the revenue that they got from the company, and they declare tax in their own annual return. The only place we have, at least in overseas, found that there is legislation towards this particular case is South Africa. We have had one case from South Africa. It might exist in other places, but we are not aware at this time. But we did have a case of a client that could make the case that they were being taxed as a tax transparent entity, and they provide the necessary proof about it. It also provides that provisional documentation to show that tax residence is being processed outside. If you are not yet tax resident in a place outside the BVI, you may apply to be, and the rules provide for a certain amount of time for you to achieve that, to actually register and become tax resident elsewhere. But it provides a certain time, it's not eternal, let's say. So the Economic Substance Act, a few words about it. It came into force on 1st January 2019 for all BVI companies and all BVI limited partnerships without a juridical personality or legal personality. It applies with immediate effect to all legal entities incorporated or formed as of 1st January 2019, meaning that those companies, their financial years started on the day they were incorporated and ended 12 months later. And then the reporting had to be done 6 months after that, meaning that we have been reporting on these companies since 1st July 2020. It introduced the substantive requirements of economic substance and also modified slightly the Beneficial Ownership Secure Search System, or the BOSS Act, to make it work together with the economic substance requirements so that the reporting could be done properly through the BOSS portal. The International Tax Authority is the competent authority to enforce economic substance requirement, meaning that any situation where there is, let's say, something that you do not understand, where you need additional information from the authorities, or the enforcement will take place on hands of the ITA.
Manuela.
And
oh,
yes,
sorry. Go ahead,
we have a poll.
We have a poll. We do.
Oh yeah, I like that. Let's go.
So let's go out with our first poll of the day. So for which of the following relevant activities have you received the most inquiries from your clients? Let's see what our attendees have to say about this.
This is an interesting one. Let's see if that goes with what we have been receiving as well.
Let's give them a few more seconds and
okay,
everyone. I see a lot of votes coming in.
Hey, that's good. The fact that we can be interactive is actually very interesting.
Right?
Oh, holding business. I'm not surprised there.
Not at all.
Okay. Well, I'll stop a little while when we go through the relevant activities on that particular matter. It has an 80% participation. Good. I'll take note. Okay. So what are the relevant activities? I think most of you will be very informed in this regard, but I'll go through 3 of those, and I will include holding business since it is simply the one that is most important for you. So the first 3, banking business, insurance business, and fund management business, it might come as not surprise to anybody attending this seminar that for these 3 activities, in most every country in the world, you would have to have a special license to be conducting any of these activities. So I do not think that one could, not know, let's say, that you're conducting banking business. If you're conducting banking business, you should have to have applied for a license wherever it is that you're going to do or carry out that activity. Same with insurance and same with fund management. The 4th one is, let's say, a less regulated one, but in most countries, finance and leasing business is taken care by the Ministry of Commerce of some sort, and they do have a license, which is of, it needs less regulation because it's not getting getting money from the public. It's lending money, but it's not getting money from the public as the first 3 do. But it's registered somewhere, and it does have a license, as I say, with less requirements, most probably in the first 3, but you should know whether you're carrying out finance and leasing business. It does happen that sometimes there are companies, or let's say groups of companies, where one of the companies leases or finances the activities of the other ones. And those cases have to be seen or examined on a case-by-case basis, okay? So headquarters business, this is one that has given us, that one has to give a little thought, because sometimes we do not, we're just carrying on our activity and our business activities, and we do not think that we might fit in that relevant activity. But let's go and examine that. And headquarters business is defined as the business of providing any of the following services to an entity in the same group, meaning in the same group, it must be an affiliated company, where it can be under, the company or the entity providing this service. It can be the parent company or can be a sister company. They might be sharing shareholders or directors or something. But it's the provision of senior management, the assumption of control of material risk for activities carried out by any of these entities of the same group, the provision of substantive advice in connection with the assumption of control or risk referred to in paragraph B. And this is a scenario that many times happen within a group of companies, and the directors of that legal entity might not be interpreting what they're doing as headquarters business. You might have one holding company, let's say, who looks after the business of the companies it's holding, and it's actually providing senior management to one of or two of those other companies. And this has to be examined, because sometimes it is happening, but our client or the client of our client is not interpreting that as being so. So cases where one company in the group has, let's say, the important or very qualified board of directors, and it's providing senior management to the other ones, may be falling within headquarters business. And this has to be looked after and has to be examined to make sure that they are not within the scope of this activity. Shipping business is another one that it's very clear in its definition, so we should not go in there. Holding business, let's go and see holding business, which is one that is also, and you just said, 80% of you said that it's important to you guys. Holding business means the business of being a pure equity holding company. And a pure equity holding company is defined in the legislation as holding equity participations and receiving nothing but dividends or capital gains from owning those equity participations. This means that this company can only own shares, quotas in, let's say, or interest in limited liability companies or limited partnerships, and can only receive in return for owning those equity participations, dividends or capital gains. If this legal entity owns anything under the sun that it's not equity participations, it comes out of the formula and it's not holding business. Let's say you have a BVI legal entity that has holds the shares of all the two companies, but it also has a judge or has a real estate or maybe a work of art. That is not pure equity holding and takes the company outside of the scope of this relevant activity. It was thought, and I need to mention this, at the beginning of the whole, in the very first months that we were going into understanding and getting acquainted with all the legislation, somebody mentioned that if you had shares on another company and you were a pure equity holding company, if you open a bank account, that would take you out of the scope of holding business. And this was dismissed a couple of months afterwards because the case was made for my lawyer in the BVI that if your business is holding shares or equity participations, and you had an account that was only meant to receive that income from the capital gains or the dividends, the bank account was an accessory to that holding business. So the bank account would not take you out will not take you out of the scope. However, if that company that holds equity participations has an account that not only receives capital gains or dividends, but let's say pays for operation expenses, then that account does not exist only to pay, to receive the capital gains, but it exists for other purposes, and then it does take the company out of the pure equity holding entity definition. I hope that helps. We have a team of lawyers, so helping or trying to guide clients through this. So you might write to marketing@omcgroup.com to get more information about this. And then we have intellectual property business, which is one that we've had a lower incidence, but it's a very important one because it's considered a high risk relevant activity because it has the highest rate of possibilities for base erosion shifts. There are some clients that place their intellectual property assets within a legal entity, and they just receive the payments and the income from them. And that one is because it has been classified as high risk. If there is any suspicion that you're carrying out intellectual property business, you have to prove, it's the only activity where you have to do that. You have to prove that you're not. And the last one is distribution and service center. And this is another activity where some clients may be doing and they don't even realize it because it's described as the business of either or both of the following: purchasing from foreign affiliates, components, parts of raw materials or goods ready for sale, or reselling such component, part, materials, and goods, and providing services to foreign affiliates. What happens if you, let's say, have a distribution company and you're buying from an affiliate and then selling to clients, you're within the description. But if you're buying from different providers and selling to clients, and neither the ones you're buying from or the ones you're selling to is an affiliate, a foreign affiliate, not a local affiliate, then you're not within the scope. And sometimes clients, we had a client that was within this relevant activity. We obtained a legal opinion, and what it took was the client to reorganize the way it was, the whole group was organized, and they stopped buying from a foreign affiliate, thus coming out of the description. And then what needs to be done? Because we need to do something, we need to report. First of all, you need to determine whether or not your legal entity is carrying out a relevant activity. Second of all, with this in mind, we developed a assessment questionnaire made available to all clients with a BVI portfolio. It's an online application. And fortunately for us, it has been, well, some clients need some additional help, but it has been working. It has been working already for over 7 months. It was early January that we launched it. And we've been working on it for 1 year already. And also, aside from the tool, we have a team of persons that are well-trained and that will help you, guide you. And if it goes beyond our capabilities, because we're not lawyers within the BVI, we will guide you through and get you a lawyer to provide you with a legal opinion that might be able to, or will be able to help you classify your company.
Manuela, yes, let's make a quick pause just to check with the audience and see how things stand with our second poll. So have you completed the self-assessment questionnaires for your entities? This is an interesting question because many of the deadlines are coming up. So we want to test the audience and see how they're doing with their assessments.
I'm hoping for 90% yes.
Let's hope so. Let's give seconds to reply and we'll share the results. Interesting.
Yeah.
Okay, let's share the results. Not quite 90%.
We need to get there. We need to get there because time's up. Time's up.
See that the
All right.
majority of people have not completed it yet. So
Yeah.
we have some work to do.
Yeah, we have a lot of work to do actually. Okay, so if your company is within the scope of any of the relevant activities, you have three options of three things you can do to meet substance within the BVI or be within the requirements. The first thing, of course, you can ensure that the substance of the relevant activity be carried out within the BVI. This means obtaining, placing up a small operation in the BVI and obtaining the 5 requirements that we will look at in the next slide. It can discontinue the activity or modify it so it no longer falls within the scope of the relevant activity. This option has been explored by several of our clients with the guidance of a legal opinion, and they have, in some cases, modified it, and in other cases, discontinued, so that they would fall outside of the scope of the relevant activity. And the third thing that they can do is it can demonstrate tax residence in a jurisdiction outside the BVI. Now you can claim that you have tax residence in any other country in the world, but the legislation requires that you prove it via a tax residence certificate, a letter from the local tax authority saying that the company is indeed tax resident in that jurisdiction, or by sending us your last tax return so we can send it over to the BVI. But you can not only, you can claim it, but you have to prove it afterwards. And then these are the 5 economic substance requirements. The rules list 3, ABC, but I was able, or we were able, let's say, to actually determine that there are 5. And the first one is that direction and management of the legal entity has to take place in the BVI. It has to have BVI directors, that qualified directors that meet in the BVI and produce the minutes showing that the activity, not the company, this is a slight difference there, is actually carried out in the BVI. That the executive decisions that lead the activity or with the way the activity takes place is actually done in the BVI. Then it needs to have the adequate expenditure, employees, and appropriate premises in the BVI, where the employees also have to be qualified as per the activity. And that's 3 requirements there. And then the last one, the core income generating activities that are attached to that particular relevant activity need to be carried out in the BVI. So while all of these requirements need to be fulfilled, the degree of overlap between them is a decision of the directors of the company. A legal opinion can tell you that you need what you need to do, whether it's better for you to materialize or explore other options. If you're going to decide, let's say, going to the back to the previous slide, that you want to achieve tax residence somewhere else, maybe it is better to hire a tax advisor that tells you where that place is the best for you. But once a lawyer tells you that you need or either modify or carry out the activity within the BVI, it is a director's decision on how many employees, how big a premise, et cetera, you need to have locally. And most probably, or the things, or let's say it moves along that whatever you're doing, wherever the company is operating, would need to be done in the BVI. This is not an absolute assessment, but it's more or less a rule of thumb. So where are we? The Economic Substance Act has one amendment and one notification on the application of Section 16. The BOSS Act is on its second amendment in connection with the economic substance. The economic substance rule are on its second version, and we're waiting for version 3, which is on the making. It's being reviewed by the European Union. The BOSS portal, these are great news, has enabled the economic substance module, which was made available to all registered agents on 12 June 2020. And we started reporting on 1st July 2020 for the first companies that needed to report. And so far, no extensions have been granted for reporting dates, either for COVID or any other circumstance. And now I will present to you, I'm happy to introduce to you Ms. Monica Reyes. She will go over the BOSS module situation. She is the one that's coordinating all of the uploading of the information to the BOSS module for OMC. Monica, please. You need to unmute your mic, Monica.
Yes, again, good morning, everyone.
Welcome, Monica.
And good afternoon to the ones that are already wrapping up. Manuel, I think we need to go back one slide and then again.
Okay.
So that we start over. Yeah, go ahead.
There you go.
Okay, so to give you some status and development on the economic substance module of the BOSS portal, annual reporting obligations as set forth in the Economic Substance Act and the Beneficial Ownership Secure Act system provides that legal entities are required to notify to the ITA on an annual basis whether these are conducting a relevant activity. Also, the registered agent is required to report to the same ITA on an annual basis via the BOSS platform whether the companies are conducting a relevant activity. Economic substance declarations may only be submitted for companies and limited partnerships companies on the BOSS portal if these have successfully filed the prescribed information for the beneficial owner. And currently, the economic substance module only allows for manual and individual input. We've been in talks with the ITA and the consultant from the BDI working on the platform. Bulk upload functionality via an Excel template may be released by mid-August, as well as the application programming interface, the API, may be released by September. So our recommendations with regards to you answering or getting your company self-assessed and then reported is very important. During this first months, let's say July and August and September, because reporting is being done manually, just because the platform does not have that capability right now. So if you need your company to comply with these reporting dates, you need to ensure that your self-assessment and the determinations that directors have made is ready on time. Next, please. So to talk a little bit about financial periods and reporting dates, companies and limited partnerships incorporated prior to January 1st, 2019, the financial period started back in June 30th, 2019 and ended the 29th of June of this year. Thereafter, the financial period will be each successive period of 1 year running from the end of that period, meaning 1 year from the end of 29 June 2020. And then the reporting deadline is 6 months from the end of that financial period. So for these companies, its reporting deadline will be December 2020. So for companies and limited partnerships incorporated, starting from January 1st, 2019 onwards, the financial period starts on its date of incorporations and ends after a period of no more than 12 months, 1 year. So similar to the other companies, this will entail, for example, if a company is incorporated today, July 29th, 2020, its financial period will end on July the 28th, 21st, and then 6 months from then, it will take them to January 2022 for reporting. So the financial period also will be each successive period of 1 year, running from the end of that first year. And the reporting deadline is 6 months, as I already explained. So we are ready for the next slide. So to talk a little bit about the economic substance module, right now it is based on a release version 1.1 of the data model. And this declares or provides for companies and limited partnerships to declare whether the legal entity carried out its relevant activity for only part of the financial period. So the platform will enable 2 sets of calendars where a start and end date may be entered for that portion of the financial period. Also, the entities need to declare whether the legal entity intends to make a claim of tax residency outside the BVI. So in the portal, the list of jurisdictions will exclude the BVI as one of the companies, and then one of the countries, and of course, any jurisdiction on Annex 1 to the EU list of non-cooperative jurisdictions for tax purposes, which you will find in the link provided as a reference. Also, entities that claim to have a tax residence outside the BVI are required to declare whether they have a parent entity. Either it holds directly or indirectly a beneficial interest in 75% or more of the shares in the subsidiary, or whether it holds directly or indirectly more than 75% of these voting rights in the subsidiary. If the latter, then the parent company will have to provide details as its name, its alternative name, its jurisdiction, and its company number. And finally, the legal entity is required to provide evidence of tax residence in another jurisdiction or evidence of its application for a provisional treatment as non-resident. Okay, I think we're ready for our very last one. Next, please. So, no, it's not the last one. So when the legal entity, I just remember, when the legal entity carries out a relevant activity other than holding business or intellectual property business, it is required to declare the total turnover for the relevant activity during the financial period, details of the persons responsible for the direction and management of the relevant activity, just making that difference between the relevant activity and the company, to declare if it's the person or the company is resident in the BVI and the relationship to the entity. Also, the total expenditure incurred for the operations of the relevant activity and the total expenditure incurred in the BVI for these operations and whether it has been outsourced or not. Also, the total number of employees engaged in the activity as a whole, if it's worldwide, and then the total number of employees engaged in the BVI who are physically present for this activity. The addresses of all premises within the BVI in connection with the relevant activity, and any core income generating activity that has been outsourced to another entity. So these are the requirements. We are covering what the platform considers required at the moment of submitting the economic substance declaration. Next, please. So, and this is the final one with the data model. When the legal entity carries out holding business as a relevant activity, it is subject to reduced substance requirements, thus only required to declare the total number of employees engaged in the relevant activity, and also the ones that are engaged in the relevant activity physically in the BVI, as well as the premises in connection with the relevant activity. Now, according to the ITA, a company or limited partnership that retains a registered agent will fulfill these reduced substance requirements just by having a registered agent. So it will be the responsibility of the registered agent to input in the system, let's say, this data in the form, let's say, of a fraction, depending on the amount of companies they have in their portfolio and the number of employees that they retain in the BVI to be able to do this declaration. Pure equity holding entities do not require to have directorship in the BVI or from the BVI. So that's important for you to know and to be at ease, because we know that holding business tends to be a little bit difficult for everyone to grasp in comparison to other relevant activities. So when the legal entity carries out intellectual property as the relevant activity, it is required to comply with points 4A through 4G of the slides that we just saw, which means total expenditures, the persons responsible for the direction and management of the relevant activity, the total amount of employees worldwide and in the BVI, the total amount of turnover for the company. So all this has to be satisfied just as the rest of the relevant activities. So next, I think we're gonna get our next point. Yeah, it's coming up, yeah. Whether the legal entity is a high-risk intellectual property that has to be declared, and whether the legal entity conducts or income-generating activities outlined in Section 7H of the Economic Substance Act, and finally, as well, a description of the nature of any equipment located within the BVI used in connection with the relevant activities. So this covers, once again, the required fields that the portal or the economic substance module in the portal requires to do the economic substance declaration. So I'm gonna hand it back to Manuela. I apologize if I went really quickly. I just need to make time for you to ask your questions. We're looking forward to them. Manuela?
Thank you, Monica. So some final thoughts, because I think that, well, we feel that some clients are like very troubled and worried about this. And we thought we would bring about the following items or the following thoughts. This is not the first time the industry has faced stringent legislation. This has been happening for something like 15 years or more. I've been in this business for over 25. And in the first 10 or 12 changes came about very far apart one from the other one. That changed about 10 years ago. And we are now faced with the situation where this business changes about every 2 to 3 years. We have a change, and we just have to, work with that. And just to remind you of some of the very important changes that we've faced before, some of the hurdles, let's say, better shares, monetization or elimination of better shares somewhere between 2004 and 2005. And most people thought that this was going to be the end of all matters relating to corporate administration. It did not happen. Stringent compliance requirements, most of them ended happening around 2015, but some jurisdictions actually started before that, and they increased the requirements quite a bit. It made life completely different for all of the companies, for all of the players in the industry. Directors filing in 2016, at least in the BVI. In other places it happened before, and in some other jurisdictions it's happening as we speak. The beneficial ownership secure search system entered in, the legislation was enacted in 2017. And there are other jurisdictions that are doing it now. It has been happening in all of the jurisdictions since then. And we also thought that everything was over, and we're still here. And the other thought is that every challenge is an opportunity. I, for one, think that if we get on board with this and do it well, this actually protects the industry in the sense that we were faced with a challenge and we were able to jump that hurdle as well as we did with the previous ones. And this gives strength to the industry in the sense that, okay, you say we're not doing things fine. You are asking of us to do this differently and organize ourselves, let's say, and be more transparent, be whatever they want us to be. And we did it, and here we are. So this might be an opportunity to demonstrate that the industry, yes, there are a few that use it for things that are not appropriate. One has to accept that. but most of us don't. And this is an opportunity to demonstrate that, to prove that to the world. Is this the end? No, likely not. I don't think it is the end. As you see, we've had challenges even more important than this one. BetterShare was, I remember the time when the jurisdictions were required to eliminate BetterShares, and you know, everybody was sulking about this. And here we are, and it's been 15 years. So likely not, because the only constant in life is change. And the faster we embrace it and the faster we work with it, everything will be easier. And we will be now very happy to answer your questions. Karina is the questions woman.
Yes, we have a few questions indeed. So let's get started. Hopefully we'll have time to answer all of them. So let's start with this one. If a company holds a yacht, does it fall in the shipping business?
No, it doesn't. The law actually provides that pleasure vessels are not within the scope of shipping business. That is not necessarily a business, it's for the use of pleasure, and it's written like that. The same happens with small fishing vessels and other, if it's under 24 meters, I don't know the technical term for that, length, it's outside of the scope.
Thank you, Manuela.
And it's also not in holding business because it's not shares, okay?
That's right.
Mm-hmm.
We've been asked to clarify with regards to holding business. If a company holds the shares and has a bank account which receives dividends, nothing else, then would it be under the definition of necessary activities or not? And what if the bank account is also receiving money in terms of operational expenses?
If the bank account receives or pays, either receives or pays, anything, actually it should only receive dividends. But if the bank account is used for anything other than receiving dividends, the bank account then takes the company outside of the scope. But that case, it would be nice if we could examine it in some more detail. So feel free to contact us in this regard. But it should take it outside of the scope.
Excellent. So we have another one here. Most clients, for most of our clients, the relevant activity is holding business. They actually have premises or employees. How can they fulfill economic substance conditions?
Well, if they have employees and they actually have premises, because the administration of these shares they are holding require all that, they would need to either materialize their presence in the BVI or find a country that provides a tax residency that it's convenient to them. I would suggest that we either guide them to a lawyer in the BVI or that they hire a tax advisor to find a solution that works for them.
That's right, and we can help with that.
We can help with that also.
Offline and help with that. So if the holding business entity receives no dividend income, is this entity within the scope or out of the scope? And this is a little bit the question that we had before, but I think
either for holding business or for any other of the relevant activities. The director of the ITA made it very clear that if there is no income in a financial period, there is no relevant activity. You still need to declare, you still need to report, let's say. But
sorry to interrupt, Manuela. Can I? Yes, just to make a quick clarification. When no dividend is received for that year, the relevant activity is still a relevant activity. What changes is the scope on how that company materializes for that year.
Exactly.
So the income will be relevant to how the company materializes its activity. but whether or not it has received income during a year does not take it out of the scope.
Thank you.
Okay.
Okay, so what?
Yeah, you don't need to materialize, or you don't need to meet this requirements for that year. But if you have the next year, then that's another story.
Exactly.
Mm-hmm.
Okay, so what about international trading of goods or services with third unrelated parties? Is this a relevant activity? I think you mentioned this, but let's...
Exactly. No, that is not a third, that is not distribution and service center. But if you are at any moment either buying or selling from a foreign affiliate, then you fall within the activity, and it is important that you consider the definition of affiliate in that sense. If you have any relationship with any of the distributors or the ones you sell to, then you might be falling. But if they have no relation with your company, you're outside of the scope.
Excellent. Okay, we have another one here. I think we have time for a few more of these very interesting questions.
Okay.
Say we have a pure holding company that can invest earnings received on the financial market. I understand that they can't in real estate or works of art. Further, can a holding company receive equity from shareholders to be later invested in other companies and invest the money meanwhile?
That is a candidate for a legal opinion from the start of that question. Yeah, I would send that case to a lawyer in the BVI to issue a legal opinion, to be on the safe side, so that this client knows what
needs to be done.
Exactly,
sure.
What needs to be done.
Yes, we can take this one as well and follow up with our attendee. Okay, so what happens to those companies who have already surpassed their due date? Can they still perform an ESR for such companies by paying a penalty? Have penalties been implemented?
Well, not yet, but if your date is due, you better report as soon as possible so that you're in the good side of the competent authority. And the faster you do it, the better will the outcome be.
Okay, we have a lot of questions that probably will not have time to answer.
Well, we can
more.
Yeah.
And yeah,
okay.
we'll reply to all of them via email and follow up. But let's take one more. If a company provides interest-bearing loans, but write it off, entire loans and interests, before the financial year ended, does this...
Sorry, start again.
Okay, so if a company...
I missed the beginning.
If a company provides interest-bearing loans, but write it off, entire loans and interest, before the financial year ended, does it still need to fulfill substance requirements?
No, it won't. But, and I would like to make that difference there. The law says consideration, which can be interest, okay? And consideration is a larger word than interest. If consideration is, let's say, I am lending, as a BVI entity, I'm lending money to you, zero interest, but I'm lending this money to the other company on the condition that he only gets it from me. That's consideration, because you're tying the loan to a condition, and that can be interpreted as a consideration. So those nuances, if they are part of the deal, of part of the condition, need to be revised, okay? Need to be reviewed in detail to make sure that it's not only the interest, but if there was a condition, that condition does not fall within the definition of consideration.
Excellent. Thank you, Manuela, and thank you everyone for the questions. Again, we will answer all of them email, and of course, if you have any further questions after, please let us know and we'll be happy to help.
All right. Thank you very much, all of you, for being with OMC today. We hope you enjoyed the webinar, and Isabel, I think, has a few last words.
Yes, Manuela, thanks. Thanks for the presentation. Thanks again to everyone for their participation. I hope this webinar was of great value for you to understand in depth the economic substance requirements in the BVI. As Karina mentioned, if you still have questions or need help from OMC to fulfill your economic substance requirements in the BVI, please get in contact with us, with your relationship manager, or send us an email to marketing@omcgroup.com, and we will be glad to assist you. Thanks again.